heard appeals in the matter of Czech Republic and Diag Human SE.
That's the line.
If I may, I'll just recap briefly the propositions that I derive from Mr. Gardner's passages in his monograph that I took you to yesterday, which is at LA 107. We needn't look at it again, but and I'm probably to pick all these propositions up, but I thought it might be convenient if I simply summarize them in one place. There is, in fact, a single rule of interpretation in the Vienna Convention, and therefore a single exercise of interpretation, taking into account all the matters referred to in the Vienna Convention. I've called that a holistic approach. It's my word, it's not his. But the key point is that there is one rule and one exercise of interpretation. Secondly, as he says, good faith is relevant at every stage of interpretation. It indicates how the task is to be undertaken, and it militates against a literalist approach. It should also be taken into account in considering the outcome of the interpretation exercise as against any rival interpretation. Thirdly, good faith has a broad meaning, which can in some contexts be equated with the rule of effectiveness, which has a Latin maxim which I'm not going to say, and which therefore on its own, as good as the good faith requirement, or in combination with looking at the object and purpose of the treaty, entitles the tribunal to have regard to the implications of rival interpretations and whether they serve the object and purpose of the treaty. Fourthly, the ordinary meaning is not the ordinary meaning in the abstract, but very clearly under Article 31.1, the meaning in the specific context in which the words are located, both the narrow context and the broader context. And here that must include the protocol to the treaty, which forms part of it. Fifthly, the ordinary meaning, unlike perhaps natural meaning in English law, it is not a dominating feature to be taken separately on its own. And as Gardner says in one of the passages I took you to, the first impression of what the words mean should be no more, and I quote, than a fleeting starting point. Sixthly, finally, the Vienna Convention brings in general principles of international law as part of the rule of interpretation, and that in turn brings in the principles of the law of civilized nations. I showed you both the provision in the convention that, and then I took you to the statute of the ICJ, where it was subparagraph C, which is the principles of law of civilized nations, which is an aspect of international law which was discussed by Lord Lloyd Jones in the lecture to which I took you to, and which, if I may say so, and I think he says this there, is assuming an increased importance these days, because 40 years ago, one generally asserted with confidence that international law was on the international law plane, as it was referred to. That is to say, the state-to-state plane of legal relations. But international law these days has many more situations in which there is a relationship between the state and either an individual or an entity, a private individual or a private entity. And in many of those instances, and as is explained by Professor Douglas, the question of control is one, and I'll come to that. There is no international law as such as to what it means to control a company. And therefore, it makes sense to refer to the principles of the law of civilized nations and their concepts of company law control and property rights. As an interesting footnote, if you went back 50 years in Soviet times, the Soviet writers on public international law thought there was no content at all of the principles of law of civilized nations, because they didn't want it to incorporate a property law, for example, from the Western capitalist concepts of property law. But that is now no longer regarded as a position, and the position is along the lines as discussed by Lord Lloyd Jones in that lecture. So applying those 6 propositions, this bilateral investment treaty should be given an interpretation which conforms with the general principles of law of civilized nations and is consistent with good faith in the broad sense used in the VCLT. Therefore, the correct approach does not require the tribunal or the court to disregard the domestic private legal position under which Mr. Stava obtained the succession planning and asset protection benefits of having no ownership interest and no legal right of control. The correct approach does not require the court, therefore, to disregard what the judge described as the rather unappealing nature of the respondent's position. And it does not require the court or the tribunal to ignore that fact that insofar as Mr. Stava exercised practical control over the shares and the company, that was not in his own right, but was done as an agent for and on behalf of the trustee, who retained control as a matter of Liechtenstein law. And therefore this feature, which the judge identified and discussed by reference to Mr. King's lecture on the Pugashov case, is not irrelevant, as the judge effectively held in paragraph 214, nor is it a matter of form, in inverted commas, as the judge said repeatedly in the subparagraphs of paragraph 215. It is of significance on the proper approach under the Vienna Convention, especially where, as in this case, there is no private international law as such on what constitutes control of a company. But there are widely recognized concepts in municipal property and company law which can fill that gap, as Lord Lloyd Jones discussed. So for those reasons, we respectfully submit that the learned judge was wrong to disregard the position, the unappealing position trust in paragraph 214 of the judgment, and he was wrong for that reason and other reasons I'll come to concentrate on what he called the form against substance position. He characterized...
Sorry to interrupt, did you mean to say there is no private international law on control of a company,
sorry,
or did you mean public international law?
I'm sorry, I misspoke. Absolutely.
Yeah, thank you.
Thank you. And so this form versus substance point is, we respectfully submit, is another product of the judge's failure to appreciate that the principles of law of civilized nations form part of public international law. And therefore, there is no reality to this form versus substance point. And the judge, I may come back to that, but the judge made 2 other observations with which we have taken issue. And I think I can deal with these quite quickly by reference to our skeleton argument. But first of all, if we could just look very briefly at paragraph 215, Roman 3, which is Core Bundle 23, page 65. In that paragraph, the learned judge, Core Bundle 23, page 65, the learned judge said that the de facto approach, which he favoured, would be less prone to treaty abuse, less prone to treaty abuse. See, I think it must be on the next page.
Yes.
Yes, it's the last sentence of Roman 3. Now, with great respect, we don't see the force in that point at all. If anything, it may be easier to contrive a a factual situation than it is to create a relevant substantive legal relationship.
Not if the legal relationship is entirely artificial.
Well, that's the case, and that is, of course. I mean, I was going to say exactly that, my lady. But if the legal relationship is entirely artificial, then that's a sham. But then equally, one could contrive a set of facts which don't reflect reality. But that's where it's very important, and I will keep coming back to it. It is common ground in this case that the trust is not a sham, and the trial was conducted on that basis, and the appeal has been conducted on that basis. It is a valid and effective trust. So if you are, obviously I accept that you could have a sham document, but you could also have sham facts. But leaving aside,
You have to be able to test the propositions, the rival propositions, by reference to facts other than these. Because obviously we accept that the trust is not a sham, it's a genuine trust. And therefore you treat it as a genuine trust. But then what the judge is saying is, well, you look beyond the form and you look at the reality of what's going on. That would apply equally whether you're dealing with legal fictions or factual fictions.
yes, exactly. So I would say that doesn't favour a de facto approach. It's a neutral factor, to use his terminology in a different context.
How can you have sham facts?
Well, you can pretend that you have de facto control and give false evidence about it, just as you could produce a false document to evidence a legal right of control. I mean, that's what I mean. It's not quite the same.
That doesn't allow abuse, because it's the function of the tribunal to decide what the facts are.
In both situations, it's the function of the tribunal to decide the case and also to control any abuse, and to, if there's a sham document, that it's up to the parties to show that it is a sham document, or if the facts don't correspond to reality, it's up to the parties to show that the facts don't correspond to reality. But I'm only on the very narrow point.
I take your point in relation to
such an approach is less prone to treaty abuse, and I don't accept that it is. And I
understand that point.
The treaty abuse point doesn't support his. It's just a neutral factor. I'm not saying it goes the other way. It's just on that last point in the last sentence of Roman 3. The other point that the learned judge made, which we see at Romans 7, it's on page 67. And this is in the Roman 7, in the next paragraph, where he says, the identification of trustee as the controller of Diag SE for Article 11C purposes would appear to have the improbable consequence that a change in the nationality of a professional service provider would change the nationality of Diag SE and its investment treaty options. Now, with great respect again, we entirely disagree with that is improbable. And if I could please direct you to our skeleton argument on this point, to cover the point most quickly. We have core bundle 18, tab 18, page 14. And we set out in 3 paragraphs there why the learned judge's conclusion about the improbability is incorrect.
Does it matter whether it's improbable or not? It would have that conclusion. Take away the adverb, it would have that consequence, wouldn't it? I don't know why you're getting so hung up about the probability or improbability of it, frankly. The point that the judge is making is it would have that consequence.
Yes. Well, we agree with that. We disagree with the. I think he's using it as a reason my argument is wrong, because the consequence of my argument is an improbable one. I'm not disputing that is the we're not disputing the case. It's the
Also,
improbability.
the point seems to me to be equally forceful, whether you take the word improbable out or leave it there.
Yeah. Because
It's an if you swapped for it the word unintended or unacceptable, it would still make the point, wouldn't it? You may disagree with the adverb or the adjective, but
I go so far as to say that it's
you say it's a desirable consequence.
I say it is certainly a consequence. It is certainly a consequence. Can I just run through the points we make? I don't want to take too long over this, but in paragraph 38, we explain why it's wrong to equate a professional trustee or trustee company with someone who is a service provider, such as a lawyer or an accountant, and we explain why trustees are chosen. That's the first point in paragraph 38. Secondly, in paragraph 39, we point out that a change of trustee is one of the most significant events in the life of a trust. And it's not at all like changing lawyers or even replacing a director. It has a fundamental impact, or can have a fundamental impact on the trust. And just to give you one example, we have the Privy Council case there of equity trust. If I could just ask, we could look very quickly at the reference that's given there, which is LA tab 90, page 6.
Before we do that, the judge is not quite right, is he, to say that a change in the nationality of the trustee would change the nationality of Diag Human, which is and always remains a Liechtenstein company. It's rather that the change would mean that a Liechtenstein company no longer qualifies under 11C.
Yeah, I think when he says
Using
that,
that
it's
as shorthand for that.
It's shorthand for change the nationality, its treatment as a national of Switzerland under Article 11C. Yeah, I'm not making that criticism. I do understand what your lordship says, but equally, I think.
Yeah, I think that's what the judge was really saying.
That's what the judge meant. But just on the equity trust case, which we now have up on the screen, Lord Reed started this very important trust case by explaining what the principal issues were. And they are as follows. Does the right of indemnity confer on the trustee a proprietary interest in the trust assets? If so, does the proprietary interest of a trustee survive the transfer of the trust assets to a successor trustee? And if so, does a former trustee's proprietary interest in the trust assets take priority over the equivalent interests of a successor trustee? And these are not idle points in relation to the trust that we are concerned with. Because if there was a change of trustee, we can look just briefly at the trust deed, SB 48, page 13. There is, first of all, clause 20, which is a slightly different point. It does give the trustees the power to change the proper law of the trust. That's one point. Then at 22, there is the power for the protector to appoint new or additional trustees and to remove trustees. These are provisions that my learned friends relies on, 22.1 and 22.2. And then at clause 28, on page 15, there is an indemnity for an outgoing trustee under 28.3. So the very questions that Lord Reed identified could occur under this trust if there was a change of trustee, especially if there was a change of trustee to one of a different nationality. So these are, we respectfully disagree with the judge's observations. And if we could go now back to the skeleton argument at CD 1814, yes, the third point is that certainly a change in the nationality of the trustee, which is what the judge's specific observation actually contemplated, is likely to be a momentous event, given that it involves cross-border implications and a cross-border transfer of the trust assets. And we give examples there in A and B, and we refer to the case of Pitt and Holt, where there was a major blunder by those advising the trust, because they had non-resident trustees and they switched them to resident trustees. Just have a quick look, please, at LA 74, page 25. And you see the facts described there in paragraph 47. Contained with incorrect advice given by the solicitors. Initially, this is just adjacent to letter G, both settlements had non-resident trustees. And then if you go to 48H, on the advice of the solicitors, there were new resident trustees. So you've gone from offshore trustees to onshore trustees, and this had a massive impact on the tax position, and that gave rise to this dispute. And so that is a prime example of how changing the nationality of the trustees, the residence of trustees, could have a huge, momentous impact on the trust, and is unlikely to be done without legal advice. But hopefully, in most cases, the advice is correct, not incorrect, as it was there. And then there's a question of the effectiveness of the protection of the courts at the place where the trustee is domiciled, which can vary. And an illustration of that is the Perry case, which we refer to if we go back to paragraph 40, which is at LA tab 93, pages 18 to 19. So could we just quickly look, please, back at thank you, that's fine, okay, fine. And this is the case of Perry, which is referred to in the skeleton argument, paragraph 40. And this was a case where, as we say in the skeleton argument, the settler's estate sought to unwind the transfer of a share to a Liechtenstein trustee on the basis of equitable mistake, because they hadn't realized that under Liechtenstein law, the beneficiaries of a discretionary trust do not have effective rights to enforce the trustee's obligation before the Liechtenstein courts. It's the very point I was making, one of the points I was making yesterday. And if you look at paragraph 42, which I think is all we need to look at, the appellant's case before Mr. Justice Siegel was that Mr. Perry set up the Lake Calmer Trust as a succession planning exercise to benefit his family, who were the discretionary beneficiaries. They claimed that Mr. Perry had a conscious belief or tacit assumption that the beneficiaries of that trust would have effective legal rights to apply to Liechtenstein courts to enforce the trustees, or trustees plural, obligations, and that he had been mistaken in that belief. They asserted that they were thereby entitled to an equitable remedy, setting aside the transfer of the shares. So these are all very significant things that can follow from changing the trustees, the residence or nationality of the trustees, to which we refer in paragraph 40 of our skeleton argument. If we could go back, please, to CB tab 18, page 14. And it is for those reasons that we disagree with the judge. Those reasons at paragraphs 38 to 40, as we say in paragraph 41, that he said it was improbable that a change of trustee would affect the position under the treaty. We say, on the contrary, in view of the major legal consequences discussed in those paragraphs, it certainly would. It could. If there is any conclusion as to what is probable or improbable, we would say it's improbable that such a transfer would have no legal effects under the treaty. Because you can see many situations in which it clearly would have a legal effect. Now, those are my initial arguments on the interpretation and some of the judge's observations about the counter interpretation. Can I now move on to my second head of argument, which is the need for a predictable and clear test to encourage and promote inward investment in line with the preamble. And if we could look again at the preamble, which is at SB 22, page 1, but this time for a different purpose from that for which Mr. Bastin took the court to it. I am referring to the 3rd to 6th lines, intending to create and maintain favourable conditions for investments by investors of one contracting party in the territory of the other contracting party, and recognising the need to promote and protect foreign investments with the aim to foster the economic prosperity of both states. Now, in my respectful submission, those aims are fully achieved on the interpretation which I urge upon this court, but they are not achieved with respect to the judge's reasoning by his approach. There are a number of points, but to put the first point bluntly, it refers to creating and maintaining favourable conditions for investments, not favourable conditions for investment claims or favourable treatment of treaty claims. It's focusing on the making of the investments, and then in the 5th line, the need to promote and protect foreign investments with the aim to foster the economic prosperity of both states. So what these words do not mean, although that is the way that my learned friends would tend to wish to interpret them, is that whenever there is an area of contention as to whether an investor is covered by the treaty, you look at this, it says favourable conditions, and therefore you should lean in favour of investment protection for that particular individual or investor. And if I could ask you please to look at my skeleton argument again, it's at CB tab 18, page 4, and footnote 2. We have it on the screen.
I always subscribe to the view, Mr. Dunning, that if it's something that's worth saying, it's worth saying in the text rather than in a footnote.
I generally agree with you. And I spend a lot of time transferring things from footnotes into the main text when I'm editing documents. This one is worth saying, but hasn't been tested in that way, I'm afraid. But this is worth saying, and it also supports exactly what Mr. Bastin was saying yesterday. Jurisdictional provisions in investment treaties are to be interpreted neither liberally, pro-investor, nor restrictively. And there's a reference to the Sprisborough and the Soto case. And therefore, it would be an error of principle to assume that outcomes resulting in more investment protection are to be preferred. And I want to just take you to the next case that's referred to, the ICS Inspection and Control Services versus Argentina case, which we can see is at LA 73, and the references pages 93 to 94. And there's a quote there, but I'd like to just show you a little bit more than the quote. And so could I look at please at but I don't think you're showing us the right page. I want to have paragraph 279, please. It starts on the previous page. Thank you. and these are 3 paragraphs, but they are important, and I'm sorry that they were in a footnote. Fourthly, the standard of consent is firmly established in international law and does not vary according to the context in which it is considered. CITs are treaties and as such are instruments belonging to the international legal order and deriving their force from the pacta sunt servanda rule of that order. EIT terms and provisions must therefore be interpreted according to the normal rules of interpretation of treaties and without losing sight of the principles and rules of international law applicable in the relations between, the page please, the contracting parties to the BIT, particularly those of a systemic nature, such as, for example, rules regarding the state's consent to jurisdiction. Echoes of what Mr. Baston said. Moreover, a state's consent to arbitration shall not be presumed in the face of ambiguity. Consent to the jurisdiction of a judicial or quasi-judicial body under international law is either proven or not, according to the general rules of international law governing the interpretation of treaties. The burden of proof for the issue of consent falls squarely on a given claimant who invokes it against a given respondent. Where a claimant fails to prove consent with sufficient certainty, jurisdiction will be declined. And just one more paragraph, 281. This principle follows, and this is another point that Mr. Baston made, and I made it briefly as well. This principle followed from the lack of a default forum for the presentation of claims under international law. Whereas the inherent jurisdiction or hermetic division of competence over claims before general courts is a common feature of municipal judicial systems, the default position under public international law is the absence of a forum before which to present claims. The absence of a forum before which to present valid substantive claims is thus a normal state of affairs in the international sphere. A finding of no jurisdiction should not therefore be treated as a defect in a treaty scheme that runs counter to its object and purpose in providing for substantive investment protection. So if I can just digress for one moment, just back onto the point that Mr. Baston was making. There are 2 critical ways in which the question of jurisdiction before an international tribunal is different from a question of jurisdiction before an English court, and which all of you will obviously be intimately familiar with. One is that the question of jurisdiction before an English court, there will always be a court that has jurisdiction. I was in a case recently we were talking about, is it England, is it Cyprus, is it Russia? But in international law, because of the default rule being that states do not consent to be sued, and because they have state immunity in relation to sovereign acts, as I said yesterday, the default is there is no jurisdiction. And there's nothing odd or unusual about that, because the states have only consented to be sued insofar in arbitration, insofar as they have clearly and unambiguously consented to be sued in arbitration. That's one difference between what your lordships are so familiar with. The other is the point which Mr. Baston touched upon, and which I think troubled your lordships on various questions, which is on his area of the case, where he was saying that jurisdiction is coterminous with whether there's been a breach or not been a breach. You know, there was that debate. But that is not at all unusual, because I wouldn't go so far as to say it's the default, but it is in many, many cases in investment tribunals. The question of jurisdiction is decided at one and the same hearing as the question of the merits. And it is only in the rarer cases where the tribunal thinks that the question of jurisdiction can be divorced from the merits that they will have what they call bifurcate the proceedings and have a preliminary hearing on jurisdiction.
Well, that's no different from domestic commercial arbitration.
No different from domestic commercial arbitration, but is very different from the questions. It explains why, for example, one has to actually decide these questions on, for example, a section 67, even though they may overlap, as indeed in a commercial case, with a question which is there a contract or not, for example. or in the prime trade case, is there looking at the scheme and on the facts under the new COGSA that came in, was there a contractual relationship or not? And it's nothing surprising that in that context the court has to decide questions of fact. But on a general jurisdiction dispute before the courts, the court doesn't decide questions of fact. It has these threshold issues, and we do have a serious issue to be tried, good arguable case, in order to avoid deciding the facts, because normally in English jurisdiction cases in court, we never do what is done in international investment arbitration, or indeed across the continent, which is decide questions of jurisdiction very often, and mostly probably, at the same time as deciding the merits. I'm sorry I digressed on that, but I thought it might be helpful. My respectful submission, those paragraphs in the ICS case, paragraphs 279 to 281 are informative and helpful. And there is further support for one of those points. If we look, please, at the Telenor case, which is also referred to there, which is at LA 68, page 52. And it's the same point or a similar point. It's paragraph 95, now just the first 8 lines. Fourthly, of particular relevance is the practice of the states parties to the BIT in the formulation of their dispute resolution clauses in BITs with other states. Those who advocate a wide interpretation of most favoured nation clauses have almost always examined the issue from the perspective of the investor. But what has to be applied is not some abstract principle of investment protection in favour of a putative investor who is not a party to the BIT and who at the time of its conclusion is not even known, but the intention of the states who are the contracting parties. So if I could now go back to the preamble in this particular treaty between these states, at SB 22, tab 1, the key words that I rely on are intending to create and maintain favourable conditions for investments, and fifth line, recognising the need to promote foreign investments with the aim to foster the economic prosperity of both states. The conditions which make an investment more likely, which promote an investment or create conditions which are favourable for investment, are those where the treatment of the investment is likely to be subject to a certain and predictable test of who qualifies as a protected investor. And conversely, uncertainty and unpredictability as to who qualifies as a protected investor is likely to discourage investment and to be inconsistent with the object and purpose. And I submit that these are important points here. I think we often read in the economics pages of the newspapers that an uncertain legal regime is a discouragement to investment. Investors like certainty, not only in the legal aspects, but in other aspects, so that they can plan their investments and their businesses. Now, on the interpretation that I put forward, the options for a would-be investor are clear in terms of structuring their investment. The investment can be made directly by a qualifying Swiss national, and that would engage Article 11A. Or the investment can be made by a qualifying Swiss legal entity engaging Article 1(1)(b), or it can be made by a company somewhere else in the world which has either a qualifying Swiss national or a Swiss legal entity controlling it de jure. And the last route, just if I can deal with another point that I'm sure will come up, the de jure control can be exercised directly or indirectly. Now, what that means is that it can be either in a company structure, for example, it can either be by the immediate company holding the shares, or it can be from the company holding the shares in the company holding the shares, or even at a third level, up the chain in the group structure.
They're genuine alternatives, are they? In that it's fulfilled if there is direct control by someone who qualifies, or if there's indirect control.
They are in terms of qualifying there. There is another provision in the protocol which we didn't look at, which is aimed at sort of disqualifying double recovery. But otherwise,
Yes,
for the purpose we're on, they are.
We're on, is whether you've got a qualifying investor.
Yeah. So if, for example,
yeah. Non-Swiss company owns the investment, company X, 100% owned by company A, which itself is 100% owned by company B.
And B qualifies because it could. B is
if either A or B is Swiss, that will do.
Yeah.
A because that's direct control. B because that's indirect control.
Absolutely. And that is what the purpose of the words directly or indirectly is for. But they do not tell you anything, in my respectful submission, as to whether that control has to be de jure or de facto. Because so it would still be de jure control if it was down a corporate chain.
I understand that.
Yeah.
I mean,
And so in that case, you might have to prove, if you were trying to prove the control of the person 2 stages up, when you go along to the state official under the protocol and he says, where's your proof of control? You might have to produce 2 share certificates. You might have to produce the one from the putative investor and the first holding of the shares, and then another certificate showing that they were held further up the chain in the corporate structure.
Yeah,
or even the third one, if you had another company involved.
I understand that. The reason I'm exploring this now is in relation to your suggestion that the parties could achieve certainty by the way they structure it, because I myself have been exercised by the fact that often control is a joint matter. You may have a single entity or a single person in control, but often you'll have multiple shareholders, and I think one must be careful to still keep in mind it's control, not ownership, but ownership may be a paradigm example of how you establish control. So forgive me for just exploring this with you. If you have my company X, non-Swiss company, in which there is a single Swiss shareholder, then it qualifies. If you have my company X, in which there are 4 Swiss shareholders, each owning 25%, does that qualify?
Well, on the judge's approach, it does, because he talked about groups. I don't know if you know, there's another part of his judgment. He talks about groups of controllers.
No, I haven't read that. But never mind what he said. What's your position?
Well, they have a legal right, but they
well, they have their own legal right as Swiss nationals, and subject to questions of reflective loss, which, as I understand it, are not much given effect to in international law. They can claim for their own individual losses by diminution of the value of the shareholding. And the question we're concerned with is whether the company itself is to be designated as Swiss.
Exactly.
By virtue of that multiple shareholding. And I can see, although at first the idea that the company isn't troubled me, I can see that may make perfectly good sense. If the individual's a Swiss national, they've got their own rights qua investors. What you're granting under 11C is a right to a company to be treated as Swiss to claim for its own losses. Now, in the case of 4 individual Swiss shareholders, that won't matter very much. But suppose one of those shareholders is not Swiss. Then if you're treating the company as Swiss, you're enabling recovery for a 25% economic interest of someone who's not Swiss. Same, to put it more generally, if you've got a 51% shareholder who's Swiss, that makes the company Swiss, and the 49% shareholder who isn't Swiss is enabled to recover their economic interest. Now that, as it seems to me, is the way 11C works, but I wonder whether that points in your favour to a more restrictive approach to the reading of 11C, in that it does have the effect through the control mechanism. If, and part of this will maybe come back to it, if the control is through ownership, and it is a control test, not an ownership test, but if, insofar as control is exercised through ownership, it does confer investment protection rights on non-Swiss entities.
Yeah, and those are all perfectly good questions. And I won't dodge them entirely, but I do say they don't arise on this case.
No, but the reason,
and I know you want to test the
no, you may or may not say that that's right, but the joint problem, if it is a problem, it may not be a problem, is one that is met, I think, by the argument that you were making, which is why I've raised it at this stage, that your 4 Swiss investors, or your 3 Swiss investors and 1 other investor, or your multiple investors, can structure it by having their disparate international interests, supposing they all got their different nationalities, into a Swiss company as the first holding company, and that is direct control, whatever the scope of indirect control is.
No, I accept those points. And obviously, if there are multiple shareholders, there may be a very simple way of demonstrating control, even if they don't have an absolute majority, because I accepted before the judge that one way, and in one of the cases this is given as an example, that you can have a shareholders agreement, and by reason of the shareholders agreement, you may exercise control.
But even without that, if you've got 10% shareholding, and therefore 10% economic interest in people of 10 different nationalities, they can nevertheless enable their economic interests all to come within the scope of the treaty by the owner of the investment being non-Swiss, but itself being 100% owned by a Swiss company in which they then hold their individual holdings.
Only, I think, if the Swiss company has real economic activities in the territory of the contracting party.
Yes, it has to be. It
can't simply have a paper company
to qualify.
in the
It has to have 2 of the 3 requirements under B. Yes.
And if this arises under the heading of certainty and predictability, if you have the kind of examples my lord is giving of joint control demonstrated by ownership of a number of people who together could control the company, do you have to show as a factual matter that they tend to work together? It might be that you have contentious issues between the controllers of the company.
Yeah. And they might have a shareholders agreement which can prove how they will resolve problems, but they may be necessary to refer to other factors.
Well, I wonder about that, because surely if you're saying you've got to look at legal control and only at legal control, then without in the absence of a shareholders agreement, then the fact that as a matter of fact every day the 3 Swiss shareholders outvote the German shareholder is neither here nor there.
No, I'm inclined to agree, and that's my primary case. My primary case is there's a legal right of control. Now, the legal right might exist in just through shareholding. It could be a feature of the memorandum and articles. In some situations, certain shares don't get to vote, but others do. There could be some other form of legal instrument, and I don't exclude from that a shareholders agreement or an agreement with regard to the management and control of the company. But it has to, my primary case is it has to be the legal capacity to control the direction of the company in its general meeting.
Ultimately, that's got to be a majority shareholding.
Or the equivalent, because you have because other shares are non-voting shares, for example.
If we're looking at control by reference to shareholdings in companies, but I go back to the point that control is not the same concept as ownership. An unlimited power of attorney, would that do?
No, I don't think it would, because you would be an agent. You wouldn't be exercising. You wouldn't be doing it in your own capacity. Now that's on the other side of the case.
Well, you might be, and that may be fact sensitive question.
Yeah.
But
these are all very good questions, but on the whole, I do say that, and I will take advice from my team, because who are no doubt.
I agree. We're spreading the.
But the feature of this case is that these questions don't arise because there's 100% block of the shares is with the trust, but the point I'm making at the moment is a general one. I mean, it may not cover every single factual situation one can contemplate, but the general point is that requiring a legal right of control provides a clear and certain and predictable test. And the question is, given the structure, I'll come back to this a bit more in a moment, but given the structure of Article 1A, which is a pretty predictable test. Are you a Swiss national under Swiss law? I know there's another argument about dominant effective nationality, which we're not running in.
No, sorry to hold it up. Can I just see if I'm right in thinking that what we're really focusing on is certainty for the investor, not certainty for the state.
Well, there is a state aspect to it, but
can I just?
Yeah.
If the purpose is promotion of the investments, in many cases, the state won't know of the investment. Leave aside your point on the protocol, but if they don't know about the investment, they won't be able to demand proof in advance anyway, and the protocol recognises that they can demand proof later when they find out. So if promotion of investments is loosely what it's about, and we're looking at certainty,
yes,
at least primarily it's certainty from the investor's point of view. Now,
exactly.
Why is it more certain for an investor that he knows he's got de jure control, and if he knows he's got de facto control?
Because he knows that he can demonstrate de jure control, essentially, with a piece of paper, or 2 or 3 pieces of paper. But de facto control could entail the very inquiry that we've had in this case, days of evidence, as to what is the position of someone who has no de jure control, but alleges that he asserts de facto control. And that's no certainty at all, because what it's saying to the investor is, you'll only find out whether this company is a qualifying investor after you've had an arbitration about it.
But the
possibly a court proceeding as well.
The discussions that we've started on, and you're entirely understandably not very keen to get bogged down in, show that there may be some very difficult questions about whether someone does or doesn't have de jure control, even if they've got the bits of paper.
Well, but what investor? I mean, obviously, if an investor wanted something simple, he would go for B, and he wouldn't take the risk of C, because C involved. But in terms of C, it is a clear test. The judge says it was a clear test, a simple test, and it has the benefit of being more therefore more safe and more predictable. I mean, everything gets argued in investment treaty cases. For example, there's an argument that 1A doesn't mean what it appears to say because there's still a rider to that of the dominant or effective nationality. But an investor would know that if they took legal advice. But if, insofar as they want to structure their investment in such a way that they can be reasonably certain that it is protected, if you're going to do it through a Liechtenstein company, you ought to understand that it would be best if you can demonstrate that you have de jure control, because otherwise you could end up having a protracted dispute, going to arbitration about it, then court appeal proceedings and so forth. And we still don't know what the answer is in this case, because even without the requirement for de jure control, I have my arguments about whether there was in fact de facto control as a matter of law.
Right, thank
So
you.
that's why it's uncertain.
You, of course, slightly, but
The very fact we're here and arguing about it, and have argued about it for days before Justice Foxton, shows that it is an uncertain and unpredictable thing. And the clear test would be more, in terms of sending a message to investors as to what is required. Structure it so you have a legal right, if you want it in. Otherwise, it's the default position that there is no jurisdiction if you don't take advantage of the other two possibilities under A and B.
Is it fair to sum up your position as being that de jure control may, in some of the cases that we've been talking about, have its uncertainties, but de facto control is always inherently more uncertain?
That is certainly one way of summarising it. I think it's probably the best way. Yes, I think for these purposes. We say, can I just for a moment, just to make one or two further points, but they're along the same lines. It's not entirely right that one should disregard the position of the states at this point either, because although we say that perhaps the main point is that the judge's approach, de facto control, doesn't give confidence to investors as to what they need to do to have a protected investor. It is relevant to look at the position of the states and whether this is. Can we just see the wording again in the preamble, the previous page, please? The need to promote and protect foreign investments with the aim to foster the economic prosperity of both states. And Vadarami was keen on the phrase "trying their luck." The judge's approach would expose host states to companies trying their luck, to use Lord of Vadarami's term, in seeking to establish claims which the states are then required to defend. And that's not really likely to foster the economic prosperity of both states. And indeed,
I really understand that. There'll be many cases in which investments are made in complete ignorance of any bilateral treaty rights. And it may well be that when they then come to look at the position, they do fall within it or they don't fall within it.
Well, that is true. That is true. But that's not the point I was making. I was saying, in terms of
I understand you'll try their luck point.
Well,
Either
does
win
it
or they're
foster
not.
the economic prosperity of the host state to be exposed to uncertain claims, have to incur huge legal costs in fighting a battle about de facto control?
I thought you were going to make a different point, which is that states need to know to which companies they can behave in an unfair and inequitable way.
Well, there is the protocol, which is the states need to know, and that's where they have a right to require proof of such control, and I'm coming to that as a separate point. I'm just on the preamble now. It is an unfortunate fact of investment treaty arbitrations that it's some of the poorest states in the world which are faced with the biggest claims, and it doesn't exactly foster their economic prosperity to be served with claims of uncertain status, where the investors, it's not clear whether someone is an investor or not, and they have to go through a whole proceeding fighting on the facts, whether there's de facto control, and then there is an appeal. I mean, just imagine, for example, if it'd been the other way around, if I'd won before this, and we were here on the appeal on the other side of whether or not there's de facto control in the circumstances of this case, or whether that's sufficient. So it is mainly for the purpose of the investor and the structuring of the investment that one needs a clear and predictable test. But it's also in the interest of the economic prosperity of both states that there should be a clear and predictable test. And can I say that there is now one award I want to take you to, which makes a lot of these points, and has a very careful and principled discussion, unlike many of the awards, of the relevant issues. So if we could look, please, at LA 66, tab 1. Now, this was an award of David Caron as the president, and Henri Alvarez, who's Canadian. But David Caron may be known to you, but he was extremely well-known international investment treaty arbitrator, one of the stars of the world, unfortunately, who died far too young. He was Professor of International Law at Berkeley School of Law and then Dean of King's College, London. And he was the president of this tribunal. And if we could start at page 50, please, and see paragraph 260. Oh, sorry, 206. The respondent objects to the jurisdiction of the tribunal on the ground that ADT is not a national of the Netherlands as defined in Articles 1b, 2 and 3 of the BIT. Respondent in particular argue that ADT is not controlled by Dutch nationals. So you can see it's a broadly similar point to the one that we have. And then if we could go please to page 55, paragraph 223.
Is the definition of investor in this case the same as or comparable to ours?
It is. Yes, that's where it arises. This control. Yeah, and then paragraph 53. Just the last sentence of paragraph 223. Thus, the difference in view between the parties is not between control and ownership, but rather between control as requiring the legal potential to control, and control as requiring the actual exercise of control. Now, there was then some initial discussion of the word control or controlled. And if we go, please, to page 59, paragraph 239. Having discussed the meaning of the words, and you could just note there's a last sentence of paragraph 237, phrase directly or indirectly in modifying the term control creates the possibility of there simultaneously being a direct controller or one or more indirect controllers.
That was the point that my law put to you.
That's the point we were discussing. That's why I just drew attention to it. And then at 239, tribunal continues the task of interpretation by considering the other two core elements of the method of interpretation contained in the Vienna Convention, the context in which the phrase controlled directly or indirectly is found, and the object and purpose of the BIT. And then if we go on, please, to page 60, at paragraph 241, they start by setting out the preamble, which similar to a lot of these preambles, extending and intensifying economic relations, it was there. And it says, and then they say, having set it out, they say, the remainder of paragraph 241, thus the object and purpose of the treaty is to stimulate the flow of capital and technology. And the contracting parties explicitly recognise that such stimulation will result from agreement upon the treatment to be accorded to investments by the national of one contracting party in the territory of the other contracting party. And then that rather chimes with what I've been saying in relation to the preamble here. And then if we could just please look at the footnote, if we could just come out and look at footnote, it says, it is widely accepted that the preamble language of a treaty can be particularly helpful in ascertaining the motive, object and circumstances of a treaty. Dalton and Stevens note in their book on BITs that even though preambles rarely contain binding obligations, they may serve as useful aids to interpretation of the treaty. And then if we could carry on, please, paragraph 242. As to the context in which the phrase controlled directly or indirectly is found, Tribunal notes that Article 1 is defining the concept of national. So, yes, Justice Wells, it is the same sort of issue as we have here. Not only defines the scope of persons and entities that are to be regarded as the beneficiaries of the substantive rights of the BIT, but also defines those persons and entities to whom the offer of arbitration is directed and who thus are potential claimants. Given the context of defining the scope of eligible claimants, the word controlled is not intended as an alternative to ownership, since control without an ownership interest would define a group of entities not necessarily possessing an interest which could be subject to the claim. In this sense, control indicates a quality of the ownership interest. The question, therefore, is how the term controlled in Article 1b(3) is meant to qualify ownership. Claimant argues that control is a capacity that the ownership interest possesses. If one entity owns 100% of another entity, then the first entity, in the claimant's view, possesses the capacity to control the other entity, and that entity is a controlled entity. For the claimant, the word control, rather than simply ownership, is employed in the BIT to address the situation where a minority shareholder, through, for example, voting rights, possesses the capacity to control the other entity. Respondent argues that control is a capacity that the ownership interest must exercise. Moreover, Respondent appears to argue that the exercise of control must be done by the owning entity itself. This is the majority of the tribunal. They went on to reject the idea that there could be a fact-sensitive inquiry as to whether ownership interest has actually been exercised. If we could look over the page, please, at page 61, at paragraph 245. So, first of all, 244, the tribunal does not find the respondent view to be persuasive for three reasons. First, the claimant's view that control is a quality that accompanies ownership finds support generally in the law. An entity that owns 100% of the shares of another entity necessarily possesses the power to control the second entity. The first entity may decline to exercise its control, but that is its choice. Moreover, the first entity may be held responsible under various corporate law doctrines for the actions of its subsidiary, whether or not it's actually exercised control over that subsidiary's actions. Okay. Let's move on then to the next paragraph. Second, respondent's argument that control can be satisfied by only a certain level of actual control has not been defined by the respondent with sufficient particularity. Rather, the concept is sufficiently vague as to be unmanageable. And we particularly stress the idea that factual control or actual control is a concept which is vague to the extent of being unmanageable.
The dispute here seems to be not so much between de jure control and de facto control, but rather whether somebody who has the de jure capacity to control is that is sufficient, or do they have to show that they are actually exercising it?
Yeah.
Is that
That's
what
correct.
this case is
and,
about?
And they are and then they reject that proposition, that latter proposition,
Yes.
on the basis that that is insufficiently clear. So I'm not saying it's on all fours.
Yeah, well, no, I follow.
But
I
I'm
just-
saying that there's a lot of very careful. You can see the level of the reasoning here. It's very, it's not dealing with exactly the points that Lord Justice Popplewell has been putting to me, but it's in the same territory of considering the same points.
And they
in
make
a
your
different context. It's
and they make
slightly
your
different.
uncertainty point at 247. And that's
Yes, well, I was going to come to 247. So I'm not avoiding the rest of 246, and I was actually going to stress the last sentence of 246. If we could just go over the page, please. Yes, I'm happy for your lordships to read all of 246, but I'm just, for time purposes, going to the last sentence. The difficulty in articulating a test in the tribunal's view reflects not only the fact that the respondent did not provide such a test, but also the possibility that it's not practicable to do so. And that, as discussed in the next paragraph, the resultant uncertainty would directly frustrate the object and purpose of the BIT. And then they come to their third point. The uncertainty inherent in the respondent's call for a test based on an uncertain level of actual control would not be consistent with the object and purpose of the BIT. The BIT is intended to stimulate investment by the provision of an agreement on how investments will be treated, that treatment including the possibility of arbitration before ICSID. If an investor cannot ascertain whether their ownership of a locally incorporated vehicle for the investment will qualify for protection, then the effort of the BIT to stimulate investment will be frustrated. Now, of course, I accept the point Lord Justice Mills put to me that they're dealing with a slightly different aspect of factual control, namely whether it's necessary on top of the right, the de jure right. But nevertheless, they still say that it's vague and uncertain test, and all that matters is having a de jure right, whether you exercise it or not. So I respectfully ask the tribunal to pay close attention to the reasoning in this case. Now, the respondents say that this case is an outlier because they say, as the judge did, that the majority of cases talk about factual control. And I respectfully submit that it's an outlier in one respect. It is one of the few cases which gives careful and principled discussion to this point. And it discusses the point of principle that arose there, which are quite close to the points of principle that arise in our case. And it concludes that a factual approach, or requiring factual exercise of control, is wrong because it is too vague, unpredictable, and uncertain. And now, if we could now go back to the judgment at C.
Sorry, just before you leave this case, I was putting to you earlier that controlled was not the same as controlled by ownership. Paragraph 242 seems to be a view of this tribunal that the only means of control which is contemplated in this treaty anyway is control through an ownership interest, not through some other interest. So that in the example I put to you of a power of attorney, that would never do. But so far so good from your point of view, but I was having a little bit of difficulty in following the logic of what is said at 242.
Yes, well, I mean, I entirely accept. I mean, and we.
Well, it may be important because
No,
if one, so forgive me for a moment.
Yeah.
If one's testing what the consequences are of the various arguments on control. If the control can only be an ownership interest, that rather narrows the field of possibilities one needs to look
They
at.
certainly seem to be postulating that, don't they? They say it's not intended as an alternative, but
They seem to be postulating it. I think we've all puzzled over that paragraph as to what the words actually mean.
Right.
I think the intent is clear. The words, there may be something went wrong with the words, because we and I think the judge below didn't quite understand the words on the page.
If the words had gone right, what is what words would you like to supply that
Well,
makes the conclusion follow?
They seem to be
as a matter of
they seem to be
reasoning?
contemplating what I would submit is, on any view, the paradigm case of control, which is ownership. And I think they've tried to say something a bit more sophisticated, and I think something has gone wrong with the wording.
well, it could be one way of looking at it is to say that the issue was whether or not the issue with which the parties were concerned was whether or not you had to have control. It was the ultimate parent and only the ultimate parent, or whether the intermediate company could qualify. That was what the issue was. And so the question, I think, was, is it enough that you own the company and you're the sandwich company in the middle? Or do you have to do something more than own the company in order to show that you qualify as the link, if you like? Or will it always be the ultimate parent? I think that's what they were getting.
That may be, in fact, I will check that with my colleagues. But if that's right, it maybe goes to answer some of the questions that Lord Justice Popplewell has been putting.
I mean, the conclusion of the majority at paragraph 264 does seem to equate control with share ownership.
Yeah.
And it's quite,
Yeah.
unless there are particular exceptions or restrictions on voting rights and so forth.
And that's why, I harp back on it, but in this case, where the judge said that he when his finding of no de jure control, if you recall in one paragraph 171, as I showed you yesterday, actually compresses two things. He held that that Mr. Starver had no proprietary interest in the company, and he had no legal right of control, and then he compressed that into no de jure control. But there were actually two elements that we argued about: is no proprietary interest and no legal right of control outside having a proprietary interest in the shares.
It may be that what 242 has in mind is that the whole purpose of these treaties, or at least this treaty, is to promote and protect economic interests. And if you were able to make your foreign non-treaty nationality company able to recover its economic interests simply on the basis that it was controlled by someone who was a national but themselves had no relevant economic interest, there would simply be no economic interest of anyone engaged by the treaty, and yet the treaty would provide protection. Maybe that's the point.
That is certainly one of the thoughts that's in there.
But whether it's there or not, I can see the force of it.
Saying it should be coextensive with a right that deserves compensation in law.
Well, it's not coextensive because we've established that if you've got a majority shareholder with control, the minority shareholder gets the benefit, although that wouldn't be an economic interest which is otherwise protected. So I don't think it's coextensive, but
I think
it does to require control in the sense of an ownership interest does prevent a case in which there is no one of the foreign contracting state who has a relevant economic interest.
so. Obviously, I could debate these.
No, sorry, I'm not just doing my thinking out loud, but I'm finding it helpful.
So, just turning to the judgment now, and what the judge did faced with this, By the way, there is another case on control, which I'll be coming to, which is gramercy, which is about how managers, the ordinary manager may be very experienced, know everything about the business. The shareholder knows very little about the business. But the manager or the chief executive is fully informed, fully in control, but doesn't have control under the gramercy test because he doesn't have any legal right of control. It's subject to the company in general meeting, and he doesn't have any ownership interest. But we're coming to that. That's a slight. It's similar to the point you've just put to me, I think. But I'm coming to it in a different part. But just on here, let's just look at what the judge made of this. If we go to the judgment at CB 23, page 55, paragraph 186. He set out, well, first of all, in paragraph 185, that's where he set out that paragraph that you were just asking me about, 242, and it says he finds that observation puzzling. I said he did. And then he says at 186, the majority of the tribunal do, however, make a forensically powerful point against the requirement of factual control, which I accept is equally applicable to an alternative freestanding test of de facto control, that it is sufficiently vague as to be unmanageable. So the judge had this in mind, but he doesn't then give it the force and weight that, in my respectful submission, he should have done. Even though, if we now could go on to page 64, in paragraph 213, in the first sentence of paragraph 213 in the judgment, he says, I accept that limiting Article 11C to control exercise through legal rights would offer a simpler solution. So he recognized that this was what he called a forensically powerful point. He also recognized the simplicity of the test based on legal rights of control. But he didn't think that that was significant, and in my respectful, he fell into error in that regard, both because he didn't bear in mind the object and purpose of the treaty, to which I've been referring, and he also rejected my submissions on the protocol and how that requires an easy process which will satisfy an official or a civil servant. And what the judge went on to do then, in paragraph 215, was to make what he called the distinction between form and substance, and that's paragraph 215, Roman 3, and it says, and he then repeats that form versus substance argument later. But if we could just pause there, I, with great respect to the judge, submit that it is incorrect to characterize this as a form versus substance debate. And it doesn't answer the point that we make, which is that if this sort of treaty regards every case as having to be looked at on its own individual facts ad hoc to decide whether there is de facto control, and not requiring ownership or legal right of control, and apparently even disregarding, as he did, the legal rights of control resting with the trustee, that does not involve a certain and predictable test which promotes certainty in the making of investments or the structuring of investments, and is out of line, therefore, with the preamble. And in any event, it is simply not apposite to characterize the dispute in this case as one of form versus substance, there's nothing formal about having ownership or a legal right of control. Maybe a layman might think it is, but in legal terms, having ownership or having a legal right of control flowing from ownership of shares is a substantive, it's a matter of substance in law. It's not a matter of form. I mean, and after all, we are construing here a legal treaty, a legal instrument, an international treaty between two states, and therefore you expect the answers to how it's to be construed to turn on matters of legal substance. And it's not an answer if someone raises a point of legal substance to say, well, that's just formalistic, because it's a point of substance in law, and we are lawyers conducting the process of interpreting the treaty. We're not economists looking at the situation without regard to the legal structure. So I respectfully submit that the existence or absence of a legal right of control is by definition, in a treaty such as this, a matter of legal substance, and it cannot or should not be characterized as a formal point. And so we pray and aid the ADT and Bolivia case. The object and purpose, as recorded in the preamble, favours a predictable and certain test of control, which is met by requiring a legal right of control, either derived from ownership or, failing that, some other clear legal right of control of the company. And there is nothing in the object and purpose of this bilateral investment treaty which justifies not respecting the substantive legal position which exists under the trust structure, and regarding that as a matter of form rather than substance. That distinction between form and substance then carries on. We're looking at it on the screen at 2153, but the judge carried on that reasoning if we go over the page, in the subsequent paragraphs, in subreading 4, he says that Article 1 evinces a preference for substance over form, and I think he's making up to the same point in 5, and will be in 6 as well. And we say that it is an error of law to regard the legal position under the trust structure, which is something that an investor should consider if he's looking to achieve investment treaty protection when he makes his investment, as something which is a matter of form rather than legal substance. Now, can I turn to the next head of my submissions, and that is the writings of Professor Douglas and Mr. Smith, and in contrast, what has been said in Professor Schroer's book on this topic. And we respectfully submit, although the judge didn't agree with us on this either, that the outcome for which the Czech Republic contends is consistent with and supported by the position articulated by leading commentators, Professor Douglas, who's a leading academic and practitioner in this field, who made exactly the same point as that made by the majority in the ADT and Bolivia case, and which we're making. If we could look, please, at his book, extracts of his book. It's LA tab 105, page 1, please. this is the book that he wrote. He wasn't. I called him Professor Douglas. He wasn't professor at the time. He wrote his monograph, The International Law of Investment Claims. And if we could then go, please, to page 2 of the extracts. This chapter is devoted to jurisdiction rationae personae. And if we go to page 6 of these extracts, at paragraph 554, page 6, please, he talks about the concept of control. And if you look at the bottom of the page, he's then discussing the Netherlands model BIT, which he says does not identify the requisite nexus in the definition of an investment, but rather supplies definitions of investments and nationals, and then extends investment protection to investments of nationals. And I think in our case it's of and by. Bastian addressed you on that. But he then goes on, the definition of nationals, and this is very close to our treaty, is the natural persons, legal persons constituted under the law of that contracting party, so less restricted. And then over the page, legal persons not constituted under the law of that contracting party, but controlled directly or indirectly by natural persons as defined in 1, or by legal persons defined in 2. So very much the same as the BIT that we're looking at, but it doesn't have the more complicated test for the company of requiring that it be not only incorporated in the state in question, but that it has its seat there and its real economic activities there. And then if we could go, please, to paragraph 556, and this is really perhaps the most important. He says, the question is then how to define control for the purpose of satisfying the requisite nexus between the claimant and the investment, and giving effect to the ordinary meaning of the word control, or the implicit requirement that mirrors it in other treaties. Reference must be had to general principles of property law and company law. So just pausing there, this is one of the key points. Professor Douglas says that you have to have reference to general principles of property law and company law. An assertion that the meaning of control in the investment treaty context is sui generis, in other words, that it's entirely a matter of international law without reference to domestic law, and thus can be tailored by a tribunal to meet the exigencies of a particular case, must be treated with skepticism. The majority of investment treaties say nothing about the indices of control, and international law in general does not purport to regulate the relationship between an individual or a legal entity and its assets. Moreover, such an approach undermines the role of the investment treaty as an instrument for the encouragement of investment, because the critical issue of whether the investment of the putative investor is covered by the treaty will be incapable of resolution at the investment planning stage. Now, there are 3 or 4 separate propositions in there, and I adopt all of those, and I respectfully submit, as I did before the learned judge, that that's a very important paragraph. If we go to the judgment, you'll see that the judge has omitted from his citation most of that and those important propositions from the 3rd sentence onwards. So if you go to the judgment, which we have at CB 23, tab 23, page 60, at paragraph 556, sorry, at paragraph 198, the judge, first of all, cites the first 2 sentences of paragraph 556. What he doesn't cite the remaining sentences, which talk about the need to refer to domestic law concepts of control under property law and company law, doesn't talk about the undesirable uncertainty and the promotion of investments by having a clear and certain test. And he doesn't cite the part where Professor Douglas is talking about the fact that there is no test of control in international law. So if we could go back, please, to tab 105 of LA bundle at page 7. So the judge misses out in there everything from the 5th line onwards. And then we should also look at what has been said in the footnote on page. And so if we could look at footnote 51, he says, Argentina has completed several BITs with a protocol setting out objective criteria for control. And we'll see that there are indeed some treaties that do have not only a protocol requiring proof of control, which is what we have in our case, but some of them go beyond and they say that means a share certificate or X or Y or Z. And then footnote 52, ADT in Bolivia, he cites the passage about the uncertainty inherent in the respondent's call for a test based on an uncertain level of actual control. Would not be consistent with the object and purpose of the treaty. The BIT is intended to stimulate, and that's the passage we've looked at. And then if we could look at paragraph 557 on that page, an investment is a bundle of rights to tangible or intangible property. The strongest form of control that an individual or legal entity can acquire over tangible or intangible property is the right of ownership. Full ownership of the property entails that the owner has prima facie unlimited privileges of use over that property, and prima facie unlimited powers of control and transmission. Next page, please. Subject to the outer limitations upon these privileges and powers prescribed by the relevant municipal law of property. But other weaker rights over property must also satisfy the definition of control, and hence the juxtaposition of the words owns or controls in the USA model BIT. A mortgage, leasehold or pledge over property would therefore satisfy the definition of control, and indeed those rights in rem are often specifically mentioned by investment treaties in the provision defining an investment. I'm not saying that the rest of this should not be looked at, so I think we should probably just look very quickly at 558, which was, so 557 was omitted entirely by the judge. 558 was quoted in full by the judge in the judgment. And that's quite important as well. This discussion of the relationship between an individual legal entity and its investment property reveals that the question of control is a question of law. It would be meaningless for a claimant to assert that it is the de facto owner of the land that constitutes its investment or has some form of other de facto control in respect thereof. Either the claimant has a power to control that property that's recognised by the lex situs, or it does not. So that's powerful endorsement of the legal test of control. And I say that the de facto test is not a legal test at all. It's just deciding every case ad hoc on the what used to be called the length of the Chancellor's foot in the old days. It doesn't give you a predictable test. And now
there's no such thing as a de facto owner of land anywhere.
no,
Most systems.
well no, quite
You're either the registered owner or the equivalent. Anyhow.
exactly. So mean, you guys, is there such thing as the de facto control of a beneficiary under a trust under which the beneficiary doesn't have any ownership right in the trust assets and doesn't have any right of control over the trust?
No, but investments are very widely defined, and one can think of a person having the de facto economic interest in the investment, even where they don't have the de jure.
Yeah, and we always have to bear in mind that a lot of these treaties have a definition of investor and a definition of investment. And one of the judge's criticisms of this passage, and I'm not sure that it's correct, is that in this passage, Professor Douglas was talking about investments and not qualifying investors. I think he's talking about both, in fact. Or he's certainly talking about qualifying investor in certain parts of it, because he starts out by talking about the Netherlands BIT, which is clearly, he sets out a definition of investor. He may be talking about both, because he talks about the nexus between an investor and investment. It's not entirely clear sometimes, but I think to dismiss this whole set of paragraphs on the basis, as the judge does, on the basis that Professor Douglas was talking about investments, not about qualifying investors, is incorrect in my respectful submission.
But his starting point at 555 is even if you haven't got control in the treaty at all, control is inherent.
Yes, exactly, because there would be some treaties that don't specify.
You can't be an investor if you don't have control.
Yeah.
And I'm not sure he's right about that, but in all treaties, but that supports the point you're making at the moment. That if that's his starting point, he is looking at investor and the investor link.
I mean, he may be looking at both here, or he may be slightly moving backwards and forwards between them, but he certainly is saying things which are directly relevant to the issue that we had to face, and it wasn't right for the judge to simply bat this away on the basis he's talking about something different. The judge did set out paragraph 558, as I said, in his judgment at paragraph 198, but he did not give effect to it in my respectful submission. Then the judge referred also to paragraph 560, which is over the page. And this is where he talks about the qualifiers directly or indirectly stipulated in a great number of treaties. He gives the example of NAFTA. And then he says the possibility of exercising indirect control does not mean that the question of law just identified is transformed into a question of fact. So it's still a question of law, albeit that it could be asked at both levels in the corporate hierarchy. In other words, control directly or indirectly does not correspond to de jure or de facto control. Indirect ownership or control means that a claimant does not have direct ownership or control over the assets comprising the investment, but instead exercises such ownership or control indirectly by having direct ownership or control of the legal entity that does have direct ownership or control of the assets. The most common example is the parent company, and he says this interpretation of the qualifiers directly or indirectly has been endorsed in ADT in Bolivia, which I've already shown you. I mean, we perhaps just look at paragraphs 561 and 562 of the page. He's again in 561 arguing against a conception of control to meet the exigencies of any particular case. It would be more principle for a tribunal to have recourse to general principles of company to develop an appropriate test. And then he talks about English company law in 562. Now, at the judgment, if we could just look at paragraph 215, Roman 2, which is CB tab 23, page 65. I'm coming back to the first sentence of Roman 2. What I say is incorrect, but he says, by contrast, I'm not persuaded Professor Douglas, KC, and Mr. Smith are addressing the particular issue before me. With respect, that is incorrect. And the reasoning of Professor Douglas is directly opposite, even if he's also talking about a meaning of investment, because he was addressing the question of the link between the investors and the investment. And he explains that the concept of control is not something that exists in public international law, so that it makes perfect sense to have recourse to domestic private law, company law, and property law concepts to establish whether there has been control. And he also explains why a legal test, rather than the de facto approach, promotes predictability and certainty, and why he disparages what he calls the sui generis approach as not doing that. Now, in the same paragraph there, as you can see, the judge also dismisses what Mr. Smith has written too. Perhaps we could just look briefly at that, which we did rely on as well. And that's at Legal Authorities Bundle, tab 106, page 1. This is part of a series of commentaries on selected model investment treaties edited by an Australian professor, Chester Brown. And the relevant chapter is on the Swiss BITs. So if we could go to page 3, please. We have lengthy extracts on typical Swiss BITs by Mr. Smith, and it's a serious piece of, as you can see going through it, a serious piece of research and scholarship. And if we could go please to page 7 on the screen, you will see that he is considering who is an investor, and he sets out one of the terms. It looks very similar. I think it's got the addition of the words effectively in front of control, but it's very similar to the treaty that we have here. And he points out that the definition of investor includes natural persons who are nationals of the contracting states according to their respective legislation, and so forth. And that, I think, is actually from the Swiss-China BIT. But he's effective. He is focusing on the question of who is an investor in a treaty which is very much the same as the one we have, except that the word effective, adjective effective, is in front of control. And then at page 8, after discussing companies in the previous paragraph, on that page he turns to companies in third-party states under effective control. And then, if we go over to page 9, he says, let's find the relevant bit. Yes, it's 6 lines down the page. He says, what constitutes control, or even indirect control, is specified only in a handful of BITs. And then we can just see there's a footnote there at 119, and then it carries on, largely borrowing from the respective GATS terminology. If we just look at those footnotes 119 and 120, he gives examples of Swiss BITs in 119, and then he refers at 120 to the GATS definition. A juridical person is controlled by persons of a member if such persons have the power to name a majority of its directors or otherwise to legally direct its actions. If we go back up to the text, please. So we've just read the text to which footnotes 119 and 120 are attached. And then it carries on in the 7th line. Some BITs require the investor to prove his control of an investment in order to be recognised as an investor in the sense of the BIT. And that's exactly what our treaty does. I mean, it has this protocol. And then if you look at the footnote to that, 121, he says, for example, the Swiss Columbia BIT in its protocol at 121 subparagraph 2c, or the Swiss Iran BIT in its protocol article 1a. And we have those on Opus. Perhaps I could ask you to look at those.
Why?
Well,
you're making a point which doesn't appear to be particularly controversial, but it's not advancing the argument, it seems to me. We all know that there may be specific treaties which specifically say what control amounts to. This one doesn't. We've got to decide whether the judge was right or wrong in determining whether it was de jure or de facto. But the fact that there's treaties out there that actually define it is not going to help us, is it?
well, I think that's correct. I can see that on one level. But the fact that these treaties, when you look at these treaties, you see that they call for things like share certificates and so forth. You'll see what, by way of example, can be taken to evidence such control. And it's if the
They don't all speak with one voice. I mean, if they were all unanimous and spoke with one voice, I can actually see some force in it. But actually, speaking for myself entirely, I don't see where it takes us.
well, but maybe I can answer that by reference to how the ADT tribunal justified the reference to other treaties. If we could go back to that, that's Legal Authorities, tab 66, page 71.
It might be simpler just to show us the treaties. I wish I hadn't interrupted.
Well, I was going to show you this anyway, so it hasn't actually altered the course of where I was going. It's LA 66, page 71, paragraphs 291 to 293. The practice of a state as regards the conclusion of BITs other than the particular BIT in dispute is not of direct value to the task of interpretation. So that's your point. The fact that a pattern might exist in the content of the BITs entered into by a particular state does not mean that a specific BIT by that state should be understood as necessarily conforming to that pattern rather than constituting an exception. So I entirely accept your ladyship's point. But the practice of a state as regards the negotiation of BITs may be helpful, however, in testing the assertions of parties as to the general policies of either Bolivia or Netherlands concerning BITs, and in testing assumptions a tribunal may make regarding BITs. That's really the level at which it's helpful to some extent to look at it. It's not state practice as such.
Practice is one of the contracting parties.
So if I may just show you I won't show you more than two, but we have selected the two. I ought to just say on the screen, there's one other point. He says, 293, most relevant to an assessment of state practice possibly bearing on the Bolivia Netherlands BITs are those BITs which were negotiated contemporaneously in the early 1990s. And so I was only going to show you, I'm not going to show you a whole load of these. I'm only going to show you two, which are the Swiss Uruguay BIT, which was 1988, and the Swiss Argentina BIT, which was 1991. So either side of the one that we're concerned with, which was in October 1990. And the Uruguay one is at LA 98, tab 98, page 3. And this is the protocol there. This goes a bit further because it also defines seat, for example. And then it's C, where you can see what they require there. The legal entities referred to in Article 11C may be required to submit proof of such a control, and that's as far as our limits go. But in this particular instance, they say, for example, being an affiliate, being economically subordinated, or the fact that the percentage of the capital stock owned by the investors allows those investors to exercise control. And the other one, which is the Argentina one, which is at tab 101 in this bundle, page 3. And it's Article 11, with reference to Article 11C, the second of the numbered paragraphs in brackets under that heading. Legal entities referred to in Article 11C, which may wish to avail themselves of this convention, may be requested to furnish proof of such control. And then it says the following facts shall be accepted as evidence: the character of the subsidiary, a percentage or direct or indirect shareholding in the company, or direct or indirect shareholding, and the number of votes necessary to obtain a positive decision. So those are the sort of documents that could be produced.
To establish economic subordination.
Well, economic subordination.
Well, that was one of the criteria in the first of the treaties you showed us.
Oh, the previous one, yes.
I'm interested in that because you do have concepts somewhere where Company A may have shares in Company B, but in fact, the reality is that Company B is financially completely dependent on Company.
Could we look back at? Could we go back then to that? Just so I've got it in front of me. I think you have the benefit of the hard copy.
It's little Roman.
Yes, I can see it now. I've got it now. Yeah.
I'm not even going to go to affiliation, but economic subordination did catch my eye.
Yes. Well, can I take that under advisement and come back on that? Delay on it now. That is what Mr. Smith has written. Now, when we took the judge to these passages, he considered them, and then in his judgment, he preferred what was written in Professor Schroer's book to those passages which are directly on the question of control, both under the Swiss BIT and under BITs generally.
I noticed, Mr. Dunning, that in one of the footnotes that you didn't take us to, in I think it's Professor Douglas's book, but it may be the other one, there's a direct reference to Professor Schroer.
Oh yes, Professor Schroer. Yeah. Well, he's a very well-known. I mean,
yes, but there's a direct for the jurisprudence in this area. Please see Professor Schroer.
Yeah, exactly. But the bit that I'm going to take you to what exactly was cited in a moment. But the bit that was cited from it's not actually written by Professor Schroer. It's in his book, but it's I think written by somebody else. Is actually about the gateway under the ICSID Convention, not about under a BIT. I'll come back to that if I may. But let's just look quickly at what the judge said. he rejected the reliance on Professor Douglas and Mr. Smith's writings. And if we go to CB 23, page 64, paragraph 211, and then 215 too, which is on page 65. CB 23, 64. That's where he refers to Troy's commentary. And then at 215, 3. Page 65, it's 2. It says the conclusion is supported by a majority of jurisprudence I have summarised and by Schroer. By contrast, I'm not persuaded by Professor Douglas.
The passage from Schroer that he quotes at 211, although he says it's not just ownership, the other factors which he brings in are in fact legal factors.
Yes, that's right. I'm just trying to find the paragraph reference to that. I've mislaid it for one moment. I think the judge refers to paragraph 322 in Schroer.
Yes, he does.
Yes.
I was simply looking at what the judge is quoted, I haven't seen the...
Yeah, and what I was going to do is take you to paragraph 322 in Schroer. I think that's the simplest way.
But he also refers to 324 as well.
Yeah, well, I'm going to take you to that part, that section. So let's have a look at legal authorities, tab 112, page 8. And this is part of the book, which is devoted to an investment, not to a qualifying investor. And it starts at 321. He says several investment treaties explicitly provide that either ownership or control is sufficient in order for an asset to qualify as an investment. And then it cites the ECT, the Energy Charter Treaty. And then there's the paragraph 322. While control is often the consequence of sole or majority ownership of an investment, ownership is not the only determining factor for control. The ordinary meaning of the word also encompasses other factors such as special voting rights and powers of operation and management often conferred through contractual arrangements. Provided the other requirements for the jurisdiction of the centre under Article 5.1 are met, the Convention accepts control as a form of holding an investment. So a few observations about this, and then the 324 is at the bottom of the page there. This is not about the definition of control in the concept of an investor under a BIT. This is, which is classified in international law as a question of ratione materiae. We are dealing with the question ratione personae of whether this investor is a qualifying investor under the Swiss-Czech BIT. So it's a different category of case that is being looked at here. Secondly, this is a passage directed to the requirement for a protected investment in Article 25 of the ICSID Convention, with which is considered in, for example, as you can see mentioned in 323. Now that is the peculiarity of bringing a claim under the ICSID Convention, if it's a BIT case, is you first of all have to qualify, you have to have a qualifying claim that for which there is jurisdiction under the BIT itself, and then you have to, if you want to ICSID process, you have to pass through the separate gateways in relation to ICSID under 25. But it's really this is really a very little or no assistance in understanding what is required to pass through the gateways under the BIT, and still less the gateway of being an investor as opposed to having an investment, which was what Mr. Baston was talking about, is the ratione materiae point rather than the ratione personae point. And just to, I can explain a little bit more. So you have to pass through both of these jurisdictional, what are called keyholes. They're both the jurisdictional keyhole under the BIT and then the jurisdictional BIT under the ICSID Convention. And because it operates like that, the ICSID Convention is generally much more broadly framed because the consent to arbitration is found in the BIT. It's only the consent to the ICSID process that you're looking for in the ICSID Convention. So the fundamental test of did this state consent to arbitrate, that is found in the BIT, not in the ICSID Convention, which is focused on whether you're entitled to use the ICSID process for that arbitration. And so the ICSID gateway is defined more broadly because it comes second and it serves a different purpose. And this was expressly recognized. I'm sorry to go back to the ADT case, but if we go back very briefly, at LA 66, Legal Authority 66, page 68, paragraph 280. And it's, I'll just read paragraph 280. Article 1B3 is an agreement of the Netherlands to treat a juridical person of one of them as a national of the other. That juridical person is controlled directly or indirectly by nationals of the other. The question is whether this definition of control in the BIT is such that disputes under the BIT pass through the jurisdictional keyhole of Article 25. In this slide, it is not at all surprising that the drafting history, commentary, and arbitral awards concerning the phrase foreign control in Article 25 all point to foreign control being flexible so that reasonable definitions in referring instruments may pass through the jurisdictional keyhole. I think, so with great respect to the learned judge, the Schroyer passage was not apposite for quite a few reasons. One is it's concerned with ICSID, two is it's concerned with an investment, it's not concerned with the BIT issue of what control suffices for the ratione personae qualification as an investor under the relevant BIT. And so with respect to the learned judge, it's actually quite puzzling why the learned judge thought that what Professor Douglas and Mr. Smith had written, which is directly in point, was not helpful to him, and why, on the other hand, he thought that the passage in Professor Schroyer's book, which is actually not in point, was helpful to him. And I respectfully submit he has fallen into error in both respects. And now I'm going to move on, if I may, to indications within the treaty wording. And the first point is that nowhere in the treaty does it refer anywhere to trusts of any kind, and therefore it doesn't offer up a ready and quick answer on the face of the treaty, otherwise we wouldn't be here. And that's why, no doubt, that the judge described this in paragraph 165 as a difficult issue. But I would invite the court to approach the wording of the treaty with this in mind. We are looking for an indication of what the host states consented to in 1990 in terms of consenting to arbitrate against a background where the default is no forum. And the investor at that point in time plays no part. when the treaty is made, as I've shown you from the ICS and Telenor cases that I cited earlier. There's a need to produce an interpretation which is consistent with the object and purpose of the treaty, and that means we submit that it should be an interpretation which is clear and predictable. And I'd like to turn now to the protocol, which is at SB tab 22, page 8. And I submit that this protocol is directly relevant and is a clear indication that legal control is required. And if I'm right about this being a pointer to what is required under these treaties, this treaty, this is a feature which is not present in any of the other cases that are cited by my learned friends and which were relied upon the judges constituting the majority of ITA cases. There weren't protocols, as far as we can see, in any of those cases. So if we're right that this protocol is a clear pointer to the legal test, then that makes the citation of all those other authorities redundant. Now, what it says is that the undersigned, this is picking it up in the second line, the undersigned plenipotentiaries have, in relation to Article 1, agreed on the following clarification, which shall be regarded as an integral part of the said agreement. An investor, according to Article 1, paragraph 1, letter C, may be required to submit proof of such control in order to be recognised by the contracting party in the territory of which the investment has been or is to be made as an investor of the other contracting party. So this is, we saw the passage in Smith where he said that some of the Swiss BITs demanded proof, and this is an example of that. And I do stress the words investment has been made or is to be made. That contemplates recognition of the investor by submitting proof of control before the investment is made. And not only that, this entire provision contemplates provision of proof of control before any dispute arises. And we have to consider what this means and how this is meant to work in practice. It means, in my respectful submission, that the host state, here Czechoslovakia, can, acting through presumably a state official or a civil servant, can request proof of such control, those are the words, and can do so either before the investment is made or before a dispute has arisen. And the obvious point is that it is relatively easy to provide proof of legal control in a form which the host state official can readily assimilate if it's a share certificate, memorandum and articles, or some other legal instrument which demonstrates the right of control. But one should contrast that with the position if the judge's test is correct, that proof of control means proof that you de facto exercise control even though you don't have any legal right of control. And we respectfully submit that A, it's inherently unlikely that that's what the state parties intended, and B, the reason it's inherently unlikely that that's what the state parties intended is how do you prove before an investment is made, or possibly before a dispute has arisen, de facto control. If you are faced with a request by an official or civil servant, can you please, if you want to be recognised, please submit proof of control. How do you do that in a complex case where there's no legal right, and like such as this one, but purely de facto control contrary to the terms of a trust deed.
Well, you might get a letter from the trustee saying, in practice, I always do what Mr. Smith asks me to do.
Well, that would be, I think the judge's findings, I need to check this, is that Dr. Rabanza would not have written such a letter.
No, I know that, but
I mean,
you're
it-
asking hypothetically.
Well, I don't think any respectable trustee would write that. I mean, because if it's contrary to the terms of the trust, they wouldn't, I mean, I don't think one can assume that the trustees act other than properly. And they're not going to certify, I mean, obviously, we come back to the debate about shams and false evidence and so on, but nobody's going to certify something which isn't the case. Dr. Rabanza is a well-regarded lawyer in Liechtenstein, as far as I can recall. He's given evidence before this court as expert on one occasion. I don't think one should imagine that anyone will certify something which isn't the truth.
I'm not suggesting they do. I'm suggesting that there's a possibility that somebody does certify the truth.
It's
You're saying in this case it doesn't apply. I get that.
well. I'm suggesting it's possible, but it's rather far-fetched to suppose that somebody will certify something which isn't the case, because there is no legal right of control or right of ownership.
How does this paragraph work, and what are its consequences? So the host state gets wind of an investment that is going to be made, and it asks for the proof of control. If the host state is satisfied with whatever is provided, so that there is recognition, what does that recognition mean legally? And conversely, if the host state is not satisfied with whatever is provided, so it doesn't grant recognition, does that preclude the would-be investor from later proving that in fact it does satisfy the requirements of control under paragraph C?
Yeah. Could I come back to this, my lord, after I've considered it over the shorter journey?
Yes, sir.
And certainly good faith would come in, so that if the state had recognised someone as an investor, it would be, I would submit, difficult for them to change their position.
They'd only be. I wonder whether there's really any real content in this, so far as the position before an alleged breach has taken place, because whether someone can prove that they had control for the purposes of being a potential investor before the investment is made won't have any bearing on whether they're a qualifying investor at the time, which is a necessary element of jurisdiction.
Well, you say that, my lord, but you say that, well, does it mean anything at all? But one of the requirements of treaty interpretation is that one is the principle of effectiveness that we saw yesterday.
Yes.
In other words, I've forgotten the Latin tag, but whatever it was. You're supposed to give meaning to all the words of the
I'm
treaty.
really adding that to the point that my lord was making about what are the consequences.
Yes.
If there's some good faith estoppel, it's an estoppel as to what, as it were, whether you had control at a time which
isn't
doesn't matter.
Well, but yes, I mean, obviously the situation potentially could change, but it gives the parties some certainty. If proof is produced and it's accepted, then at least as things stand, unless they change, that is the person is then recognised as a qualifying investor under 11C.
And you get the alternative, you see, which seems to me to be slightly more problematic, is suppose that the putative investor can't get their hands on the share certificates at that time, for whatever reason. So they can't satisfy the treaty party that they're a proper investor, but in fact they are. They do have control at the appropriate time. There's then an alleged breach of the treaty, and at that time they produce the share certificates. They can't possibly be precluded from doing that by the fact that they didn't produce them at an earlier stage.
No, that's not my point. That's not my point at all. I mean, it's just simply that there is a process that the parties have gone to the trouble of setting out in their treaty, and this is not the only treaty. There's a whole raft of treaties which Switzerland has entered into, which has protocols like this. Some simply asking for proof of control, some spelling out what control documents will be accepted as proof of control. But one can't assume that the parties did this not intending it to have some legal effect. To the contrary, treaties are to be construed as giving every part of them some legal effect. And what the legal effect it does give is it is an indication of what these state parties regarded as the relevant type of control at the time in October 1990 when they entered into this treaty.
Well, it may be the answer is that even if the term isn't intended to have any binding effect as to the future in either direction, it does at least, from an administrative point of view, serve a purpose for the state in question. That gives it some effect without it giving rise to any form of estoppel in either direction. And I see the force of that, and it does require proof of control, and if proof of legal control is easier and more certain, and proof of de facto control is more difficult and less certain, then that's just an extension of your point about certainty generally. I understand all that.
Yeah.
What at the moment I'm not getting much out of is the distinction you're drawing between the proof coming before the investment is made or the dispute arises and the position later.
Well, before the investment is made, there may be no practice on which you can demonstrate factual control. You can demonstrate you're the only owner of the company, but nothing may have happened to demonstrate factual control. That's the point I'm making. There may be no history to prove at that point in time. But you can prove you own the company. You have the legal right.
Where the company's just been incorporated, for example.
Yeah. And it hasn't made an investment. It hasn't done anything. How do you prove practical control? But you can certainly prove legal control because you can produce the share certificate or the articles and memorandum or whatever that showed that you are the person who controls this company. But there may be, this is a really important point, there may be at that point in time no possibility of proving de facto control because there is no history to go by.
But conversely, that doesn't matter because de facto control at that point of time is entirely irrelevant to rights under the treaty before the investment is made. That's I understand the point you're making. I just wonder.
It does matter because
weight it has.
No, it does matter because that's exactly what an investor wants to know before he structures his investment this way, whether it's going to be protected. I mean, he doesn't want to make an unprotected investment. So it does matter to the parties to know what the position is before the investment is made. That's the predictability point. Am I going to have? I mean, you could even envisage a situation where an investor might ask the state to ask it to provide proof, and to give it the comfort of knowing that it will be regarded as a protected investor.
I don't think that's an entitlement under this protocol.
Not an entitlement. No, I agree. It's not an entitlement. And
this is only something that the state can require.
Yes, but you could write to the state saying we're proposing to make this important investment. We would appreciate it if you required us to provide proof, and we will then provide proof, and we will have the comfort of knowing where we stand.
You could do that even if this protocol didn't exist. We wouldn't be entitled to an answer in either case.
Exactly. I entirely agree, but this protocol indicates the type of control that's in question. And I'm not at all interested in any of these process points or the consequences of the operation of this. But this can only operate effectively, in my respectful submission, if it's proof of control means proof of legal control.
No, but I'm making a slightly different point. You were making a point that there's an advantage to the investor arising out of this protocol. this isn't a provision which is for the benefit of the investor. It's solely what can be required by the state, isn't it?
Yeah, so
But one's looking at what its purpose is from the point of view of the state, not the investor.
But if the state does exercise that, it will have a benefit for the investor because he'll have certainty as to whether he's regarded as controlling the relevant investor.
Well, the state knows that if it provides the recognition, whatever that amounts to, then the investment is more likely to be made.
Yes.
And therefore, going through this process, in the case of an investor who wants reassurance, will promote the object of the treaty because it will make the investment more likely to happen.
Yeah. I mean, this doesn't happen in the case of Mr. Starr because he didn't know about the investment treaty. But you can imagine a big company, they're going to put up a car plant or somewhere. I mean, these sort of investments don't take place without some interaction with the relevant government. They may say, we want some comfort. And the state might say, well, in that case, we'll ask you for, as we're entitled to do, for proof of control. And then you provide it and you'll have the comfort. And there's a process there which can be gone through and which will provide some certainty to both parties, but only, in my respectful submission, if the test is a simple one to apply, which can be done by officials or civil servants without having to conduct some sort of factual inquiry in relation to a business which may not even have got going, may not even have started, may have, as my ladyship says, may only have just been incorporated before the investment is, before its investment is made. Now, where I respectfully submit the judge went wrong on this is we say that this is a clear pointer to a simple test of legal control, and the judge regarded it not as being a pointer at all. This is CB 23, page 52, paragraph 175 of the judgment. Czech Republic suggested reference to proof in Protocol 1 supported its case that control via legal rights or involving an ownership interest was required. However, de facto control as well as de jure control can be proved, and I regard the reference as neutral. Now, it's true that you can prove in for example, an arbitration, de facto control, but in the sort of context we're looking at, where you're anticipating that state officials may be requiring proof of control, it's much more likely, we respectfully submit, that is intended to refer to de jure control rather than some sort of complex de facto control which contradicts the de jure position, as indeed the judge held. So we submit this as a clear indication of what is required, something which can operate entirely at the planning stage before the investment is made, and the judge, and it's likely to be in the form of a brief submission. Here's a document or a few documents that prove that we have the legal right of control, before there is any investment history to demonstrate the de facto position. And we say, therefore, that paragraph 175 is an error by the judge. He was wrong to conclude that there was no indication in the treaty, in the protocol, that the legal test of control was required.
I suppose you might also contemplate that a legal opinion from a lawyer in the relevant country could be supplied.
The legal test.
So if it's a legal test, whereas which might satisfy the host state,
yes,
it's harder to do.
I mean, this is where the protocol, other protocols that I showed you a couple of, but there are others in the bundles, do show the sort of documents that the state, by way of example, has required, and their share certificates, evidence of majority control, those sort of things. I suppose that could be done by a lawyer's affidavit or opinion in certain circumstances, if it was sufficiently clear cut. Particularly if it's governed by a foreign law, because I suppose it may be necessary to explain, certainly to provide translations, but it may be necessary, I suppose, to provide an explanation of the effect of a legal instrument as a matter of foreign law. But these are all quite simple, clear-cut ways of demonstrating control.
How does that work if it's not a question of whether to make the investment, but how to structure it?
Well, because if you are unable to satisfy the state that the putative investor under 11C is in fact controlled by
you won't be able to at that stage because you won't have set up the structure.
No, but you can set up the structure before you make the ultimate investment into the Czech Republic. You can set up.
You can,
yes,
you can. But
yeah.
I thought one of your points was that it would enable the potential investor to devise the structure in a way which was going to achieve the objective.
I'm sorry, there's another loss of the point. Devise the structure in a way that gets approval, or if it doesn't get approval, devise or go down a different route. So that you do get you do qualify. So I didn't quite finish this.
They've got to put the structure in place.
Put the structure in place. They say, does this work? If the answer is no, you haven't proved legal right of control. I mean, they can either then structure things so that there is a legal right of control, or they can go down one of the other routes, or they can decide they're not going to make their investment because, I mean, the simplest route is to have a Swiss company and make its seat in Switzerland. I mean, we are talking about the exceptional case here, where this is a company from Timbuktu, or could be any country in the world that happens to be subject to, on the judge's test, de facto control, contrary to the terms of a trust, which will then qualify it, even though it's a foreign company, for protection under the Swiss Czech BIT.
It doesn't have to be a company. One of the things that 11C contemplates are legal entities which are neither Czech nor Swiss. So it may take a form which is permissible as a legal entity under whatever system of law governs it.
Yes,
so
it's got to have it's got to have legal personality.
But legal personality, but that may. I mean, we're obviously using company as a.
Yes, we are
as a paradigm example.
There are other entities. There are entities that have legal personality.
But a huge number. I mean, it's not a finite range of those one finds in the Czech Republic or Switzerland. That's my point. It's potentially.
It's the whole world.
It's potentially a lot of creatures, including a temple in Tamil Nadu or whatever it may be. Yep.
Right.
Or the goddess.
Well, on that note, shall we adjourn till 2 o'clock? How are you doing for timing overall?
I've got quite a way to go, but let me just see. I think I'll be a fair bit of the afternoon. But,
you think you'll finish this afternoon then?
I would hope
Because
so,
you've still got your second.
I think that's going to be.
Deal with.
I mean, there are really only factual references.
All right.
There are no authorities to go to on that aspect.
Very good. 2 o'clock.